our CCPL book series. Today, we are deeply honored to have Professor Katalin Sulyok with us to discuss her new book on the role of science in environmental adjudication in international law. Dr. Sulyok has earned her degrees in biology and also in law from Harvard and ELTE. And she has also been holding visiting positions from numerous prestigious institutions across the globe, including the Max Planck Institute in Germany and the Budapest Center in Cambridge University. And her new book is based on her dissertation. It's about science and judicial reasoning, the legitimacy of international environmental adjudication, which just came out with Cambridge University in 2020. So without further delay, Dr. Sulyok, the floor is yours.
Thank you so much. Let me try to show my slides. Please, could you confirm that you see it properly? Thank you. So good afternoon, everyone. I'd like to thank the organizers for having me here today. It's a real privilege to talk about my book in this prestigious series of Hong Kong University. So as has been mentioned, my book on science and judicial reasoning has grown out of my PhD research that I've conducted mainly at my home institution, ELTE University in Hungary, Budapest. My research interests have always covered the overlapping areas of law and science due to my dual background. So this is why this book is the first book-length answer to such interdisciplinary queries, which really focuses on how the presence of scientific arguments shapes and transforms the judicial process, and especially judicial reasoning. So I structured my presentation into four main parts. First, I'd like to set the scene by addressing some major trends in international environmental adjudication, and I will introduce the theoretical framework of my book, which proposes that the main challenges and many of the shortcomings of environmental litigation can be traced back to a threefold challenge, which is posed by the presence of scientific arguments in the courtroom. Then I'd like to address the analytic framework of my book, how I conducted this comparative case law analysis, focusing on the various forms and strategies of judicial engagement with science of international courts. And then I'd like to discern you some trends in environmental adjudication. So I'd like to present you some of the main findings that came out of this comparative case law analysis of 6 major types of international jurisdictions. And then I'd like to focus on the interrelations between science and the legitimacy of judicial decisions, because all my comparative exercise at the end of the day boiled down to addressing this issue, because I do think that, that science is a disruptive factor, but also can be a major ally for international courts to accrue legitimacy for their reasoning and decisions altogether. So let me now turn to what I call the threefold challenge of environmental litigation. And first, I'd like to give you just a picture for those who are not experts in this field. What are the main features of environmental adjudication on the international level? So we see a proliferation of such disputes in recent decades. I use the term environmental disputes in a very broad sense. So I regard every dispute to be of environmental character that contains an environmental component. Such disputes are raised before various fora within various branches of international law, ranging from the law of the sea through regional human rights to investment protection or WTO law. Common to these disputes that they are all science intensive. By saying that, my book means that they all contains and entertain questions in which science and law are deeply intertwined. Science inevitably underlies these disputes, which would suggest that science and scientific arguments become legally relevant in these disputes. The ubiquitous nature of scientific arguments and scientific evidence would intuitively warrant a significant profile for environmental arguments in litigation, yet my case law analysis suggests that this is far from being the norm. In fact, we see that various differing levels of science are allowed to enter the judicially relevant sphere of legal disputes. For this reason, my research sees international judges as gatekeepers who are willingly or unconsciously apply judicial tools which adjust the level of science that is allowed to be considered by the bench in resolving the legal disputes. So in order to give you some concrete examples, what types of legal dilemma we are dealing with in such disputes, let me refer to some concrete examples. So let's first consider the Gabčíkovo-Nagymaros judgment of the International Court of Justice, in which the court was asked to rule on the permissibility of the plea of Hungary on ecological necessity. In applying the international law regime governing ecological necessity, the court had to rule on the imminence of ecological risks based on bulky and highly technical scientific evidence. In more recent cases, international courts, the ICJ included, increasingly asked to rule on environmental liability claims. And as soon as international courts have to entertain environmental responsibility for environmental damage, they confront causality, they have to establish causality based on uncertain scientific proof of causation, which will pose problems for their analyses. Scientific evidence is also frequently submitted to WTO panels in the dispute settlement mechanism of the WTO. For instance, in the beef hormones case, the panel was asked to rule on whether the US can legally institute a ban on hormone-treated meat from the US on account of or on the basis of scientific evidence which suggested health risks of consuming such meat. So the question here is whether it is a genuine and lawful ban on certain products, or whether it is a discriminatory measure which seeks to impede international trade and therefore it is unlawful. Similar questions arise in the realm of investment protection. So here, the frequent dilemma put before investment panels is what concerns whether the host state instituted a genuine, scientifically motivated and lawful measure as an exercise of its police powers to address certain environmental risks, or whether the measure which is harmful to the investment of the investor can be regarded as a disguised protectionism. And in deciding this dilemma, scientific evidence will again be relevant. And lastly, let me refer to the famous judgment of the International Court of Justice in the whaling case, where the International Court of Justice was asked to define or decide what should be regarded as scientific research for purposes of the Whaling Convention, whether the Japanese JARPA whaling program can be regarded as being conducted for purposes of scientific research. So these are the sort of typical questions or dilemmas in which science and law are deeply intertwined, and international courts will have to face these questions directly or indirectly. The queries at the heart of my book are the following. To what extent science is actually considered by different fora in deciding such science-intensive disputes? What are the procedural and argumentative techniques they apply to include or exclude scientific arguments in their assessment? What is the prevailing trend, if there's any, in international adjudication in this respect? What are the risks and benefits of incorporating or downplaying science in the judicial process, especially in the reasoning? And how courts can craft a persuasive, convincing, and epistemically legitimate reasoning in such scientifically loaded disputes. So all my inquiry at the end of the day came down to addressing the interrelation between legitimacy and scientific authority. And in this respect, my book asks the questions whether scientific authority is a prerequisite to creating and crafting legitimate legal reasoning, or whether legally authoritative and legitimate judgments can be crafted in a persuasive way, irrespective of scientific knowledge relevant to the case. So the theoretical framework of my book proposes that there is a threefold challenge posed by the presence of science, and many of the difficulties international judges experience in such cases can be explained by these challenges. I distinguish between epistemic, doctrinal, and legitimacy challenges. Epistemic challenge stand for the problems that are rooted in the fact that science is present in the courtroom as a cognitive authority, which is hierarchically not subordinate to legal and judicial authority, and therefore it poses difficulties for international judges to be interpreted, because it is not at their full disposal as the law and the facts are at their disposal in regular litigation. Doctrinal challenge arises from the fact that the scientific and the legal realm in fact speak two different languages. Science and law have different notions of causation. They have different conceptions of what a reliable evidence is, and they have differing levels of tolerance towards uncertainty. And finally, legitimacy challenge arise because in deciding these disputes, international courts either may inadvertently delegate their judicial tasks to non-elected experts, or they may run the risk of making epistemically arbitrary decisions. So for all these reasons, my research suggests that scientific arguments shape the dynamics of the adjudicative process in idiosyncratic ways. And this is important because so far scholarly literature has only distinguished mainly between factual, policy, and legal arguments, but scientific arguments as such have not been addressed directly in the literature, and this is what my book seeks to do. So I'd like to problematize the presence of scientific arguments. I'd like to investigate their epistemic nature and discern and identify the peculiar challenges they pose for the entire adjudicative process. Epistemic challenges are rooted in the fact that legal adjudicators are normally not trained in science, which entail that they are sometimes intimidated by its cognitive authority, because science challenges the discretionary monopoly of international courts to decide such disputes as they deem fit. Another problem in this respect is that truth claimed by science may be in conflict with truth claimed by law in certain legal and political cultures. Suffice it to refer to the divergent discourse on climate change. So while the scientific community has long reached a consensus on the peculiarities and causes and the impacts of climate change in certain political legal culture, it is still very much debated. Another very important point is to emphasize that sometimes judges have unrealistic expectations what they can get from science. So we see in the reasonings that sometimes they expect to receive objective truth from scientists. They expect clear-cut, black and white, and certain answers. However, it's important to emphasize, and there's tons of literature in the science and technology studies field, that science can only provide culturally situated knowledge. There are many social conditions that determine how scientific knowledge is actually created. And at the end of the day, scientific results are produced by scientists who are human, so they are fallible. So for all these reasons, these expectations are not unrealistic, and it's important that international judges be aware of what they can actually receive from scientists. Still, we see that scientific arguments carry great strategic importance for litigants. So actually, we see that litigants are competing for who can successfully appeal before the court to the authority and the cognitive persuasive nature of science, because the one who can win the sort of cloak of science for its argumentation, in many cases, this party will win the case, or will have better chances of winning this case. So now doctrinal challenges manifest in some structural differences between how law and science functions and how lawyers and scientists think. Suffice it to refer to the fundamental difference between how laws are constructed in the scientific realm and how normative laws, man-made law, are functioning in the realm of law. Again, there are a fundamental difference between how causation and causal links are conceived. While lawyers tend to search for and tend to prefer finding linear causal links where every effect has a distinct cause. You can see this chart on the top of this chart. Unfortunately, the scientific reality is much more complex than that. So Unfortunately, scientific reality is about causal complexities, and we should think about causal relations as complex causal webs, where there are concurrent causes, where there are partial causation, but where there are no single but-for causes, or it is very hard to find sine qua non distinct causes of a certain environmental harm or an environmental phenomena. And then science has a different notion of what constitutes a reliable proof. So while scientists have an agreed mathematical probability threshold called the significance level, the P level, which designates scientifically valid results in a research, judges use the standard of proof threshold, and they emphasize that the standard of proof cannot be translated to a mathematical probability. So judges usually emphasize that this is a very subjective value. The judge has to be certain about this, whether this threshold is met, and it varies from case to case, from circumstances to circumstances. And lastly, the last structural differences which I analyze in my book is the comfort with uncertainty, how law and science tolerates uncertainty. So while scientists are absolutely comfortable with the fact that science can only produce probabilistic results, no matter how well science progresses, scientific results will always be probabilistic. Law has an ingrained need for certainty. The judge has to ascertain about the facts of the case, and certainty is a very much a disruptive phenomena for legal analyses, as we will see in the causation and causal inquiry of international courts. So legitimacy challenges arise when judges seek to choose to neglect scientific advice, but also when they choose to become too dependent on it. So when an international court decides to appoint experts and to rely on expert advice in deciding scientific disputes, then they run the risk of delegating their judicial authority to non-elected experts, which will raise legitimacy challenges. The other extreme solution would be equally problematic when a court decides to solve these science-heavy legal questions on its own without receiving expert advice, and then they risk epistemic trespassing, which means that they risk making epistemically arbitrary judgment. Epistemic arbitrariness means that when a validity of a knowledge claim is judged by standards alien to it. So for instance, when the validity of a scientific evidence is judged by not scientific rationality, but by legal rationality applied by the legally trained adjudicator. So these challenges raise a number of questions during the adjudicative process. What is the appropriate level of deference afforded to the scientific claims of states and litigants? How courts can maintain epistemic control over the fact-finding process and expert evidence? How they can stop trespassing? And with what types of authority a court can legitimately replace scientific authority, which it does not have, to legitimately decide a science-heavy dispute. So now, after these theoretical remarks, let me move to addressing the analytic framework of my book, how I compared and analyzed the notion of judicial engagement with science. So I coined this term to refer to a host of divergent strategies and practices of international court, with which they interact, engage with, reflect on, comment on the scientific aspects of dispute. I argue in this book that science poses similar challenges for all these adjudicatory stages. And in fact, my book seeks to measure, identify, and then measure in a fine-grained way the various judicial reactions which are given by judges to the presence of scientific arguments at the various stages of the adjudicative process. So the first stage is the framing of disputes, whether international courts decide to include scientific questions within their assessment, or whether they seek to circumvent and avoid confronting with scientific questions by excluding such questions from the ambit of their dispute resolution process. The second stage is conducting scientific fact-finding, in what ways and what types of expert advice an international court receives. The third is how they establish causal links based on uncertain evidence, whether they are willing to relax causal standards to lower the threshold of proof and thereby establishing a legally relevant causal link on the basis of probabilistic evidence, or whether they set a higher threshold, require clear causal links, and thereby dismissing such uncertain causal claims. The last stage is the standard of review and setting the scope of the judicial purview, which basically means how much deference they afford to scientific claims of the parties. So the bulk of my analysis is, on the one hand, is a comparative analysis. I compared approximately 200 judgments handed by 6 major types of international jurisdictions: International Court of Justice, interstate arbitration, regional human rights courts, investment protection arbitration, the WTO dispute settlement body, and the International Tribunal for the Law of the Sea. All of these chapters start with analyzing the entry point for science, so these are the sort of legally contextualized questions through which scientific input invades and pervades the judicial process. And then I identify and examine the judicial techniques each respective fora applies at the 4 stages of adjudication. So let me now turn to my actual findings. So what are the trends in the scientific engagement of these international fora? So first of all, it is important to note that I propose that there is no unified trend in the practice of how international courts approach science in their assessments. In fact, we can find 2 parallel trends. One is downplaying science. The other one involves those judicial tools which seek to accommodate science. So we see that certain jurisdictions in certain cases go to great length to integrate science in their assessment, while we still see a host of judicial tools which seek to impede or even preclude the intrusion of science into the courtroom. It's important to note that downplaying in this context does not refer to situations when judges rule against science-backed claims. In my view and in my narrative, downplaying science only means how the courts reach their conclusions. So when judges reach conclusions in scientific debates without actually considering scientific input, this is what I call downplaying. Another important thing is that we just cannot neatly group jurisdictions to science-friendly and science-evasive categories. The picture is more nuanced than that. The science intensity of the inquiry of the same jurisdiction may vary across the different stages of the adjudicative process. So it may very well be, and it is often the case, that the same jurisdiction which is inclined to include science in its framing techniques, it will exclude scientific arguments during the causality and the causal inquiry stage, for instance. Nevertheless, we can still say that there are some jurisdictions are more open towards science, and I suggest in this book that it very much depends on the mandate and the underlying law of the fora. So those fora seem to be more open to science, that have an underlying law which already contains express scientific legality criteria, and those which have a more narrowly construed mandate seem to experience legitimacy deficit to dig deep into the scientific aspects of disputes. So for instance, investment panels and human rights courts are markedly shy in terms of their scientific engagement, and this may be partly explained by the fact that they have a very specific and narrowly construed mandate, which does not include exploring the scientific profile of such disputes. So my comparative assessment includes insights from international claims commissions and international claims tribunals, such as the UN Composition Commission that administered liability claims after the Gulf War, and also the US Marshall Islands Claims Tribunal, and also I included some references to potential good judicial practices from domestic case practice, such as US toxic tort litigation and climate change litigation, because these are extremely science-heavy questions in domestic case law, and thereby I suppose that some solutions can be informative for international jurisdictions as well. So in the interest of time, I would like to only briefly address these. So these are my detailed findings, but I will only flag a few for you now. So what are the actual judicial tools that I identified from the practice of international courts as to the 4 stages of the adjudicative process? As to framing, we see that some, the majority of jurisdictions do regard science-intensive legal questions as justiciable. However, there are still proposals, mainly proposed by minority positions of international benches, which suggest that science-intensive questions should be deemed non-justiciable. Another accommodating technique as to the framing level is to prescribing expert-led consultation. For instance, the ELTE applied this technique in the swordfish dispute, where it prescribed in its order for the parties to appoint experts and engage in an expert-led consultation. And in the award, so in the decision of the tribunal itself, it harnessed the cognitive authority of science by outsourcing science-intensive questions to experts, but by exerting control over this negotiation process, and thereby it retained control and oversaw this process, and thereby it benefited from expert advice by ordering in its final order that the final legal regime be based on what the experts suggested. In contrast to that, we see downplaying techniques such as those applied by the ICJ in its Kapchikovo judgment, where it basically just referred all scientific questions back to the parties' open-ended negotiations. So the court did not want to oversee this project. It did not refer to the way how these experts are selected. It only noted that these science-heavy aspects be decided by the parties as they deem fit, and there is no surprise in that these negotiations have failed for several decades and are still futile. It could not reach an effective solution for science-heavy aspects of disputes. As to scientific fact-finding, we see a great gap between what the actual procedural powers granting to international courts and what powers are actually used. So while we see that many or virtually all 4 would have power to use ex curia experts, so independent experts appointed by the judicial body, very few have ever used such powers. And while the majority of courts do regard the scientific evidence submitted to them as legally relevant, we still see certain decisions which I term as Solomonic judgments, in which this evidence, this scientific evidence, is not considered by the court, and the court rather decides such disputes based on other non-scientific aspects of the cases, and essentially disregards the scientific evidence submitted by the parties. As to causal inquiry, we see that science can be integrated in the analysis, for instance, by creating presumptions, causal presumptions, because presumptions allow the court to breach the uncertain scientific evidence with law's need for certainty. And by applying this presumption, causal findings, legal causal findings, can be based on uncertain scientific evidence, or relaxing causal tests. So relaxing rigid causal doctrines also allow courts to make legal findings, definite legal findings, based on uncertain scientific facts. While we still see practices of downplaying science in the causal doctrine by setting too high threshold of proof for causal claims, or by applying what I call proxy-based causation. This is very typical in the practice of the Strasbourg court, in which a causal link between toxic emission and the resulting health injury is not entertained or investigated based on the scientific evidence submitted by the applicant, but based on non-scientific so-called proxies that are intuitive circumstances, as for instance the distance between the applicant's home and the toxic emitter's premises, and if the applicant lives close enough to the toxic industrial facility, then the causal link is established. But if she lives a bit further, then the causal claim is denied. So in this sense, the court escapes confronting with scientific evidence, and it will decide the fact based on non-scientific considerations. As to the standard of review, we see that some courts are less deferential and they conduct a de novo review by which they have to integrate science in their assessment. And for instance, the reasonableness test is such a more intrusive review. It was used by the ICJ in the whaling dispute. So in order to decide what constitutes scientific research for the purposes of the International Whaling Convention, the ICJ crafted this reasonableness test and said that it will find the research project as being conducted for scientific research if it is reasonable. And this reasonable in order to apply this reasonableness test, the court had to evaluate expert evidence and expert arguments. So in this case, it involved science in its legal inquiry. But we still see tons of and a host of practices with which international courts can easily escape confronting with science. For instance, some afford total deference to the scientific claims of litigants. Others refer to standards of international organizations or international regulatory trends as indicia of credible science. So in this case, in order to decide whether a state referring to genuine environmental risks, the courts will not entertain scientific evidence in this respect, but will only check whether the certain respective harmful substance is present on any scientific standards issued by international organizations such as the World Health Organization, and if it is, then they will find this scientific argument as legitimate and credible, but they will not want to engage in a discussion with the experts. What does it say for us in terms of the legitimacy of international courts? My main hypothesis in this book is that the ways in which international courts choose to engage with science, or they either integrate it in their assessment or downplay it in their analyses, will fundamentally impact the available reasoning techniques they have in which they can legitimately argue in a legal dispute. So in case international courts choose to accommodate and integrate science in their assessment, this will create a need for gathering epistemic support for the judges to be able to choose from competing science-based knowledge claims. Whereas if they choose to downplay science in their assessment, this will create a need for finding non-scientific epistemic authorities and epistemic benchmarks to support their findings in the reasoning. So this is how we'll reach the stage to discuss the interrelation between scientific authority and the legitimacy of judicial reasoning. So the legitimacy of international courts is usually approached through the lenses of sociological legitimacy and normative legitimacy. But my book takes another approach and uses the so-called epistemic legitimacy as its focus, which is rooted in the realization that providing well-reasoned judgments is also a requirement to claim legitimacy by a certain judicial body. And in the context of scientific knowledge, it means that inadequate treatment of scientific knowledge in the reasoning would ultimately result in unconvincing and opaque reasoning, which is epistemically arbitrary. Again, epistemic arbitrariness means when the validity of a, let's say, scientific knowledge claim is judged by legal or intuitive standards, so standards alien to the scientific rationality. In this respect, my book, and the main message of my book, is not that using more science by the bench would necessarily result in better reasoned judgments. Rather, I suppose and propose that the key in this respect is how courts interact with scientific authority. So in the last chapter, my book seeks to answer three main questions. The first is how disputes closely tied to scientific facts can be persuasively decided with or without relying on scientific rationality. So I do not suggest that international courts always have to refer to scientific rationality. The picture is more nuanced than that. The other question is, how can judicial reasoning conform to both the logic of law and science? Because this is the main rule of preserving epistemic legitimacy. So the international courts have to be aware of the logic of science as well in such disputes, and not only the logic of law. And finally, my main question is, when can an international court reason with science, and how it should do so, and whether it can, and if so, under what conditions, can reason against scientific knowledge implicated in a given case. So I distinguish between 4 main types of reasoning styles in my book. The first one is scientific reasoning, when the reasoning directly builds on scientific authority. The other one is the legal reasoning argumentative pathway, in which the findings of the court are validated through legal logic and through legal constructions, which are only available for legally trained reasoners. So an everyday people could not apply such a reasoning technique in a legitimate, epistemically legitimate way. And then I distinguish a peculiar category within legal reasoning techniques, which I term hybrid reasoning. And hybrid reasoning contains hybrid notions, which are amenable to judicial appraisal, but which are situated in the law-science interface. This means that, for instance, concepts such as reasonableness or coherence or consistency are present in both realms, both the scientific and the legal realm, with slightly different meanings, yet they're robust enough to coordinate and maintain coherence during the cooperation of law and science in the courtroom. So they function as translation points. A very beneficial feature of such a reasoning is that the application of these hybrid notions, such as reasonableness, in order to decide what is reasonable, a court of law has to look closely to the scientific facts. So this reasoning technique ensures the accommodation of scientific authority in its assessment, yet it does not allow epistemic trespassing. So the application of such notions, such as interrogating the reasonableness of a research scheme, let's suppose, perfectly fits in the epistemic competence of legally trained reasoners. So they are not asked, and they're not even permitted to rule on the scientific reasonableness of claims. They have to confine their reasoning and inquiry into interrogating the legal reasonableness of such schemes and claims, which falls in the heart of what judges actually do. So the act of the deciding on reasonableness is actually an act of balancing, which is something that international courts and judges in general are very comfortable to do, because this is what they actually trained to do. And another beneficial nature of such a reasoning technique is that courts of law can formulate their own reading of what they believe to be reasonable or consistent or coherent, which means that they are not become dependent on expert advice. So it in a way, it ensures their autonomy from expert opinions, and thereby they can maintain their control over the fact-finding process. And lastly, I distinguish between, or differentiate, a 4th type of reasoning style, and this is what I call intuitive reasoning, where international judges refer to common sense wisdoms and they make everyday inferential shortcuts, which can be especially an appealing solution when they are faced with highly technical scientific knowledge claims, so making inferential shortcuts make their job much easier. Before turning to concrete examples, I'd like to emphasize that each of these reasoning and argumentative techniques have their own benefits and trade-offs in terms of preserving the adjudicatory control over the dispute, in terms of preserving and observing epistemic non-arbitrariness, factual scientific accuracy, and practical feasibility. And let me now, just very briefly, because time is running, some of these reasoning styles from the practice of international courts. So A typical scientific reasoning technique would be relying on scientific evidence or appointing independent experts or expert arbitrators on the panel, conducting a de novo, a very intrusive assessment of the scientific evidence submitted, or referring to standards of the scientific community in terms of legally selecting what can be regarded as a credible evidence. The risk of such reasoning method is that the courts may inadvertently delegate their judicial tasks to the experts on which they rely, and they may fall prey to partisan evidence. And so a general solution, a remedy to such cases would be to enhance the scientific capacities of international courts by training in science provided to judges or staff members, and a more frequent reliance on appointing ex curia experts. A typical legal reasoning technique would be is when international courts refer to the scientific standards issued by international organizations, because in such a case, so I deem such a reasoning technique as a legal reasoning technique, because applying standards of the WHO, so the World Health Organization, does not necessitate a scientific literacy on part of the judge. It rather functions as a checklist criterion. It has to check whether the substance, the harmful substance in question, which lies at the heart of the legal dispute, is present on the standard of the international organization. And if there's a match, then the judge will rule in favor of the party who would like to regulate this substance. But in order to apply such a standard, there is no need to understand the scientific subject matter of the debate and to know actually and understand the toxic potentials of the material. The problem of such a reasoning technique can be that such standards are not numerous enough. So there are many emerging environmental risks and toxic substances that are not included in such scientific standards. So such a reasoning technique would not be available in every case. Another typical legal reasoning technique is applying presumptions, because the persuasive force of presumption is not does not refer to science. So it is not scientific authority which underlies the persuasiveness of such a presumption, because presumption is crafted despite the lack of scientific knowledge. So here we find presumptions persuasive because we are trained as lawyers. So it is legal authority, legal logic, which ultimately underlies such a reasoning technique. So my conclusion in the book is that the antidote to these epistemic risks and trade-offs of legal argumentation is that such reasoning tools can be applied by international courts, but only as a complementary means of justification when scientific reasoning techniques are not available, or when science is infinitely uncertain, which precludes its usage in a legal setting. So let's consider the intuitive types of reasoning. For instance, the causal proxies that I've mentioned before in the practice of the Strasbourg court, where intuitively appealing everyday logic underlies making a causal finding as to the or causal link between a toxic emission and the resulting health damage. The risk and downside of such reasoning techniques that it is actually detached from scientific reality. So we know that toxic substances can actually travel long range and they will not lose their toxic potential. So basing a causal finding on the intuitive intuitive criteria of how close the victim lives to the dangerous facility is actually contradicts scientific knowledge on toxic substances. So I conclude in this book that such intuitive reasoning style can only be applied as a last resort, and it cannot be used to replace scientific knowledge. scientific authority. And lastly, just a few examples from the hybrid reasoning style. The reasonableness test, which the ICJ applied in the Whaling test, is such an example. Because in order to decide whether the Japanese whaling program was reasonable, the court had to look closely at the facts, yet it perfectly fitted in its epistemic competence to expound such a notion as reasonableness, because a court of law is actually trained to do so. So the only prerequisite to apply hybrid test is that courts have to actually basically understand the basic scientific dilemma. So they have to have strong epistemic competence for the bench, but then again, this can be improved through applying scientific capacity building techniques. So what is important to note here is that I do not suggest that there is any abstract hierarchy between these reasoning techniques. I do believe that they all have their rightful place and role in the judicial toolkit of crafting reasoning, but some are better suited under specific circumstances. So like intuitive reasoning can only be applied as an ultima ratio tool. I also argue that legitimate argumentative space is quite wide, actually. So illegitimate, epistemically legitimate forms of reasoning are only located at the two extremes of this hypothetical argumentative space. So either when international courts want to replace scientific knowledge with, for instance, intuitive knowledge, or when they think that it is their task to solve the actual scientific controversy, because it's very important to know that it is not the role of courts to decide the actual scientific debate. They have to decide the legal debate, which is very much dependent on science in many respects. So now my last slide, and I'd like to just summarize what my final message is in the book regarding what the judicial task is in scientific disputes. So I conclude that science not only poses challenges for international courts to craft legitimate reasoning, but science and scientific authority and the cognitive authority of science can be an important ally for international courts to accrue legitimacy for their decisions. In order to harness science's cognitive authority, courts must interact with science in a legitimate way. So they must be aware of the risks and benefits of different reasoning styles, and they must conform to the logic of science as well by preserving the epistemic legitimacy of their decision. It's important that judges need not rule on scientific validity of claims. They only need to be able to choose from competing science-based claims and choose one as legitimate for purposes of the legal analyses, but they do not need to enter scientific debates as such. In order to do so, and the final aim of my book is to raise awareness among international judges of the legitimate argumentative space and these four types of reasoning techniques which they can apply under certain circumstances. It's very important that that in order to prevent epistemic trespassing, I suggest in the book that international judges must be aware and must be ready to formulate a basic understanding of the scientific subject matter of such disputes. And lastly, I suggest in the book that that factors conferring legitimacy on a certain judicial body change over time. And in order to make this point, my book uses draw an analogy with the King Solomon decision, and this is why you can find that Raphael's painting on the cover of my book on the judgment of Solomon. So you obviously all know the story that King Solomon was asked to decide in a dispute between two women who all claimed to be the mother of a baby. And I argue in this book that such a dilemma, so King Solomon dilemma, is very much similar to science-intensive modern disputes, because this legal controversy boils down to the question of biological motherhood, in which the DNA evidence would be the final proof. Obviously, King Solomon did not access to such a scientific proof to decide this matter. So he had to design an astute way of revealing the identity of the mother. He ordered the baby to be cut in half, and this prompted the real mother to give the baby to the competing woman, which move revealed to King Solomon the real identity of the real mother. So he gave the baby to the biological mother. So for centuries, these decision was deemed the archetypal example of making a wise and legitimate decision. And I do not contest that. My only point is that such a Solomonic descientized decision in which the court decide a genuinely scientific dispute without having a view to science will not be regarded as legitimate anymore. Of course, King Solomon was right because he didn't have access to DNA evidence. But international courts in the modern era are put in a very different place because they do have the power and the opportunity to seek expert advice, but they often decline to do so. And the main message of my book is that in the 21st century, when science pervades human life and human existence to an unprecedented extent, and it invades and pervades social institutions alike, international adjudication and adjudication as such cannot be immune to the presence of science. They must follow suit. International courts must be ready to engage actively with science. They cannot rest in their ivory tower of legal adjudication. And I do suggest that the proper and adequate scientific engagement of international courts are consequential in our times, also because there is an increasing competition between jurisdictions, and ultimately, in the majority of cases, the parties do regard scientific evidence relevant to their case. So they will ultimately bring their matters to those fora which are willing to entertain their claims in their entirety, scientific aspects included. So that would be my brief, hopefully brief opening remarks, and I'm very much looking forward to receiving your comments and questions.
Thank you so much, Dr. Sulyok, for this very informative presentation. And first, please allow me to congratulate you on completing such a marvelous book. When I was reading it, I was so impressed by the breadth and width of your analysis. I think to understand the interface between law and science in the practice of one international tribunal is difficult enough, and you were able to do 6 international, to compare the practice of 6 international tribunals and to weave them into one framework to understand the law-science interfaces. And this is totally fascinating, and I think it's an invaluable contribution to multiple strands of literature in international law, especially the empirical studies of international law and international adjudication, and the interdisciplinary study of law and technology, and also the comparative study within the realm of international law itself. And for those that have an interest in one or more of those issues, I strongly recommend you to read this book if you haven't done so already. And before I open the floor to the general public, I have 2 questions/comments of my own, and both are more from an institutional and political perspective of understanding the relationship between legitimacy of those international arbitrators and the role of science in judicial reasoning. The first question is, I definitely agree with you that in the contemporary world, with the expansion of technology into almost every aspect of our daily life, it is almost inevitable for international arbitrators to deal with scientific issues. And this capacity building for international arbitrators to engage with scientific reasoning is important to maintaining the legitimacy, the institutional legitimacy of those international arbitrators themselves. But on the other hand, I see that from many of the examples that the cases that you've provided in the book, it seems to me that in many cases, especially when the court tries to adopt a more balanced or hybrid approach to sort of balance, on the one hand, the recognition of the authority of scientific evidence and expert opinions on the one hand, but also to retain the court's power to intervene and to examine the legal aspects of those scientific evidence on the other. This approach seems to have generated more uncertainty and inconsistency and unpredictability in the adjudication. And this itself may also hurt or present a challenge to the courts in terms of maintaining its own legitimacy in international adjudication. So I wonder, in terms of these sort of pros and cons for engaging in scientific reasoning in their adjudication, how do you think the international tribunals should balance those different benefits and costs of this approach? And this is my first question. And the second question, and I'm talking more in conversation with your chapter on the WTO's practice in this area, that I understand that in many other cases, it seems that for the courts to adopt a more sort of engaging approach to scientific reasoning, it seems that it will allow for more open-ended debates to examine the competing scientific evidence, so that it could lead to a more sort of open-ended or case-by-case analysis of the court. But in the specific situation with WTO, it seems to me that especially when we're talking about the issue of necessity in the public policy exemption in Article 20 of GATS, it seems that when the dispute resolution body wants to adopt a more intrusive approach, it will inevitably lead to a more, say, a preference of the freedom of trade over, say, the state's discretion and over public policy for the purpose of protecting its health or natural environment. Whereas if the dispute resolution body adopts a more deferential approach, then it will more likely lead to a decision that is more in favor of state discretion in public policy protection, rather than to uphold the principle of freedom of trade. So I wonder, in the cases like this, especially for the WTO, how do you consider that other factors other than the relationship between law and science per se, factors such as political and normative values of those arbitrators and those institutions, might have also affected the different approaches that those arbitrators, those dispute resolution bodies have chosen in specific case? That's
Thank you so much.
2 questions. Thank you.
Yeah, thank you for these excellent comments. I'd like to organize my thoughts first. So the first question concerned the pros and cons of scientific engagement of courts to. So what are the dangers of direct scientific engagement of international courts? If I understood you correctly, and yes, you're very right. So it is not. So there are many dangers of doing so. But I do believe that it is a necessary step that international courts have to make. So but of course there will be some traps and dangers along the way, because the first danger is that they may become too dependent upon the advice they receive, and we see this problem of the partisan evidence. So scientific evidence of the parties can be biased to such an extent that it would be actually inadequate or not suitable enough for the court to base its findings on the evidence, because of course science can be distorted, and this is what I was referring to when I mentioned that science cannot supply objective truth to litigious context and the litigious process. Judges must be ready to be able to single out those scientific references which are biased and work more like a sham and these keys for other political motivations or other non-scientific motivations. So one of the thing that international courts could do is, and many or some of them are doing, is to appoint expert judges or expert assessors. So the Permanent Court of Arbitration and ITLOS have such powers. So this would be one way of guarding against partisan evidence and becoming too dependent on expert advice. Expert judges are regular judges. They have the right to vote, but they don't have a legal background, or next to their legal background, they have PhDs in relevant science. This is what we saw in the Kishan-Ganga arbitration between India and Pakistan before the Permanent Court of Arbitration, which was a water allocation dispute or a hydrological plant, a dam was built by India, and then the question concerned what is the minimum environmental flaw which had to ensure by India on the waters of the Kishan-Ganga in order not to destroy the environment of the downstream state. And in this instance, so it's a very science-heavy question, but of course these questions and these legal dilemmas are not only scientific, there are lots of social, industrial, economic, political, social dimensions of these disputes. So I do not claim in this book that we should only concentrate on science, because the reality is more nuanced than that. My proposal is only to accommodate first the logic of science. And once we did it properly, and once the international courts did not escape easily this task, so they formulated their basic understanding of science, they heard expert opinions, they understood the scientific aspect, then they are free to move on to consider other aspects. So I do not believe that these legal disputes should be decided by experts, or experts' findings should dictate the answer. And this is actually what we saw in the Kishan-Ganga dispute. So we saw that there was an expert arbitrator serving on the panel, a scientist in hydrology. He is a very esteemed scholar in hydrology, and he was one of the judges. So it ensured that the reasoning of the tribunal was very correct in terms of the science, and it made very fine-grained legal findings as to what is the minimum flow requirement to be ensured by the hydrological plant in order not to destroy the environment. But the actual minimum flow requirement was actually lower that the tribunal finally set, because then they moved on and then they considered the industrial interest of the Indian economy, and that they factored in other wholly non-scientific considerations. At the end of the day, the environmental flow requirement was set at a lower level than what would have been prescribed by solely scientific considerations. And I argue in this book that if we see scholarly reactions and evaluations of this decision, we see that this award did not trigger as much criticism as usually every other environmental decision. So previous environmental decisions, such as the pulp mills decision of the International Court of Justice, or the Gabčíkovo decision of the Environmental Court of Justice, they were all concerning water allocation and water pollution disputes, were heavily criticized. There were, in the pulp mills case, there were tons of dissenting opinions, and even members of the bench heavily criticized the approach of the majority. The Gabčíkovo case also concerned the construction of a dam, and the scholarly literature was basically uniform in terms of the expressed criticism of how science was handled. So the Kishan-Ganga arbitration for the first time was not a so-called pro-environmental decision in its purest form, because environmental interests at the end of the day were overridden by economic considerations. Still, in terms of how science was handled, this decision is one of the best in my view. So what is the most thorough in terms of how science is approached. Of course, there is still ample room for criticism in terms of how sustainable development and other policy ideas and principles of international law were factored in, and whether it is really a fine and fair balance between economic and environmental considerations. But these criticisms can only be articulated from a normative standpoint and from the normative environmental law standpoint. And my book and my approach and my arguments confine themselves to epistemic legitimacy. So my book does acknowledge that environmentally friendly decisions may not be epistemically legitimate, and epistemically legitimate decisions may be not always good for the environment. So So my point here, I guess, to your question is that there are many procedural ways of safeguarding against becoming too dependent on the expert advice courts receive, and that epistemic legitimacy is only one aspect of a good decision. And of course, after meeting this criteria, there are a host of other criteria of how courts can make good decisions. My only problem with this book, by writing my book, was motivated by the problem that this aspect of writing a good decision, I mean, epistemic legitimacy, was completely missing from the picture. And I'd like to raise awareness about this aspect, which is which should be, or I'd like to hope that it will be, an important aspect for international judges of how to approach scientific debates. But I have to also acknowledge that such procedural powers as appointing expert assessors or expert arbitrators are rarity in international practice. For some reason, international courts just do not want to do that. And I believe that it can be partly explained by really the intimidation of international judges from the cognitive authority of science. So they are used to the very comfortable situation that they know the law and they will apply the facts to the law. So so actually the facts and international legal rules are at full disposal for international judges, and scientific facts and scientific authority does not fit in this very comfortable scenario, because if judges will not consider science in their assessment, then it will haunt them later on, because scientific arguments give a very powerful tool to the hands of critics of particular decisions. And now let me turn to your second question, which concerned the concerns over so if the WTO panel applies an intrusive approach, then it may hurt or curtail the public policy powers and the sovereign powers of states. And I have to agree with you. So the very delicate balance have to be struck. And again, my point here is that first they have to be correct in terms of their scientific engagement, and then they are free to give deference to the state on grounds of the public policy point of view. So my point is not that the intrusive scientific analysis should also result in a pro-free trade decision. My only point is that if such normative considerations of certain panels, so in case they want to rule in favor of the free trade, then they should not cloak this approach in a scientific language. So please do not abuse scientific input in order to rule against the public policy sphere of a member state, because this is just an abuse of science's cognitive authority. So I do believe that there is a legitimate concern, and there are lots of debates in the literature in terms of whether the WTO panels should be more deferential towards the sovereign policy choices of states. And I think it's right and justified concern. And again, my point here is that we have to distinguish between the grounds of deference and the grounds of intrusive review. So I think that just because a state is referring to scientific evidence and the complex scientific knowledge, it is not a rightful ground for affording deference. Making sovereign policy choices can be, as long as it fits in the normative framework of the Article 20 exception of GATT. But what we see actually in practice, the science is used as a shield. Oh, I have a scientific opinion. Oh, I have some experts who are very knowledgeable in the field, and they raise some scientific concerns. And with this, states actually can insulate their normative choices from judicial review. And this is what I try to argue against in this book, that this is just epistemically arbitrary, so we should not do so.
Thank you, Katalin. This is very helpful. And just allow me to ask another very quick clarifying question. So I wonder, when you study the 6 international tribunals, have you seen them practicing a different level of willingness to engage scientific experts when they are adjudicating on science-related issues? Or is there a past dependence in terms of their willingness to engage experts?
Oh, thank you. Again, excellent question. Yes, there are market differences in terms of their willingness to do so. So the most extreme ones are human rights courts, regional human rights courts. They have the worst track records, if I may say so. So like the European Court of Human Rights, before the European Court of Human Rights, applicants regularly submit scientific evidence. The court does have the power to appoint its own experts and to hear expert evidence, and it never did so. So this is one of the extreme solutions. And then other jurisdictions evolved a lot. For instance, the International Court of Justice had a long way to go from its first environmental disputes, which was decided on its merits, which was the Gabčíkovo dispute back in 1997, in which it only noted within one sentence the bulky scientific evidence submitted by both Hungary and Slovakia. So actually only the Hungarian scientific expert submissions weighted 12 kilograms. So it was really like heavy and bulky in every sense. And then the Slovakian party also submitted several scientific rebuttals. So there were separate submissions that each party dedicated as scientific explanations and scientific rebuttals for the arguments raised. And the court noted only in one single paragraph that it did not find important, it did acknowledge the scientific complexities and the scientific uncertainties involved in the case, but it did not find it necessary to rule on them in order to decide the dispute. So this was sort of where we started scientific engagement, one sentence versus several kilograms of scientific papers submitted by the parties. And then many decades later, in 2018, there was the compensation judgment issued by the same court in the certain activities case, where the court was willing to consider and monetize ecosystem services of forest fell down by Nicaragua on the seashore, and then the court was actually willing to consider what is the monetary value of the various ecosystem services provided these forests and mangroves, which is like astonishing, especially if we see where this very court started its scientific engagement. So some are trying to do a better job, and then of course ad hoc investment panels that are constituted on a case-by-case basis have a very divergent approach to scientific questions. It depends very much on the identity of the arbitrators. So we see a very scattered practice in terms of investment arbitration practices. But on the long run, I do believe that there are hesitant signs of spring. So we see that in virtually in every forum, there is a growing awareness of the fact that we just cannot escape reflecting on science. Science keeps coming to us, so we have to do something with it. So I do believe that the Strasbourg court's practice will also change on the long run, and so overall, I have an optimistic view based on the case law review which I done.
Okay, thank you. And now, if the audience, if any of you have any question, you can use the Q&A chat box. And if Alex wants to ask some question, you can unmute yourself and speak up. So Alex, please go ahead.
Hello, I'm glad to have had the chance to hear that. It was a really fascinating presentation, and I'm really looking forward to reading the book. I think this is just such vital work and interesting, as was said earlier, for a number of reasons. So one question I had for you, because you've looked closely at this, is where more specifically you think the problems are for capacity building in terms of the type of scientific understanding that is most challenging for judges. So it occurred to me that, it could be like domain specific knowledge about, say, climate science, or say AI decision making. Could be, these sort of domain specific knowledge problems, or it could be a kind of like the transferable skill of understanding statistics, or maybe it's a mixture of both of these things. But it seems like there would be a different approach to addressing the capacity problem depending on what was more challenging. I'm curious actually anyway, just what it seems like judges have the most trouble with, because a legal education doesn't necessarily prepare you for either of those things, but perhaps one of those things is a bit easier for judges to skill up in than the other. So I'm curious to know what you think those challenges are. What is most challenging about that?
Thank you so much. Yeah, so I do believe that one of the biggest challenges is to really understand what science can actually deliver. And this goes back to my theory on doctrinal challenges. So I think it would be very instrumental to have to adjudicate international judges about the ubiquitous nature of scientific uncertainty, and how scientific uncertainty cannot be precluded. It will always be there, no matter how well science progresses. So I think from the language of the decisions of international courts, we still very much feel that they just do not want to accept it. They wait for clear causal links. They wait for clear proofs of causality, which is just wholly idealistic. And I think so that will be the sort of the entry requirement. And of course, there are many other jurisdiction-specific knowledge. For instance, in the law of the sea, of course, specific knowledge is required, but I think it would be very beneficial just to really have a one-on-one course on what is the scientific logic, how scientific evidence is produced, what is this p-value, how we should cope with uncertainty, and what causality is. I mean, causal doctrine is something which is really the cornerstone of legal education, rightly so, because liability, is at the heart of the legal enterprise. But if we look closely at how causal webs and causal complexities are at play in environmental disputes, then emphasizing this but-for causation and sine qua non causation is really a hopeless exercise. You just cannot find but-for causes in such a causal conundrum. And actually, this is why I examined climate change litigation and the US toxic tort law, because they are they're very rich in innovative causal doctrines. So at the end of the day, I do believe that the international courts have the burden of being creative. So they have to relax some of the legal doctrines in order to provide effective answers to the challenges that we are all facing. Climate change litigation is very innovative in terms of causal doctrines. US toxic tort law can be very enlightening in terms of causal proof requirements, how it can be relaxed, how statistical probabilities can serve as a legitimate basis of making legal findings about liability. So yes, I think you're very right. We have to distinguish between a basic understanding of science and scientific logic, which would not be an unrealistic capacity training. So my point is not here that all international judges must become experts in hydrology, because it's just unrealistic. But they have to be comfortable with understanding how statistics works, how this p-value works. And actually, why I'm very optimistic is that Professor Mark Mangle, who acted as Australia's expert in the whaling case before the International Justice, has a very enlightening piece published in the PNAS journal in the US. So he's a mathematician, actually. So this piece was published in a scientific paper in a scientific journal. So he he wrote basically this piece about his experience with the International Court of Justice, acting as an expert in a very high-profile environmental dispute before the International Court of Justice, and his account is very optimistic. So he openly wrote that actually the international judges did a very fine job with understanding what is the basic dilemma here, about how statistics work, how statistical probability, what are the basic rules of doing scientific research. So actually, I think we should give the credit to international judges. They could do a much better job if once they're willing to do so. So I think we have good chances of I think a small change in attitude can bring a lasting change in terms of the legitimacy of the outcome, basically.
That I mean, that chimes well with my experience having taught some quantitative methods to law students. There's an initial sort of fear because they don't expect to have to understand numbers in law school. But then when you get over that, it, because, law students and lawyers and judges are smart people and they can grapple with these things when they get over the initial intimidation factor. And also the thing you said about I think this also really chimes well with my experience, is that there is an impression from outside science that science is much more sure about things than it is. So when they hear that, oh, well, there's some doubt, there's only a 95% confidence that this is the case, they think, oh, well, there's a 5% chance that it isn't the case, and then dwell very much on that degree of uncertainty. So yeah, I think this is very, I am persuaded by your optimism that it is possible for us to have capacity building in these areas for both law students, practicing lawyers, and judges as well. So thanks very much.
I'm happy to hear. Thank you. Yeah, so I do believe that environmental adjudication is undoubtedly is an interdisciplinary exercise, and in this interdisciplinarity, in this sense, places a very heavy epistemic burden on judges, because in like policy making, interdisciplinary means that let's ask the experts what they say, and then let's hear what they say. But in the context of adjudication, where the judge is vested with the power to make the final say and the final rule, this interdisciplinary alliance is not so easy. So they just cannot simply outsource the science-heavy questions to experts, but they have to understand. But really, just the basic dilemma here, and this is why I think that this hybrid way of reasoning is very consequential and important, because judging the reasonableness, coherence, and consistency of science-based arguments is something that the judge can comfortably do. So they do not need to assess the scientific credibility of the scientific expert evidence, but they just have to ascertain that the science-based reasoning is reasonable enough in order to be deemed legitimate within the frames of the adjudicative process. So I think, yeah, we have to distinguish and differentiate between what is scientifically legitimate, which is validated through scientific method within the scientific community, and what is legally legitimate, which is a matter falling for and preserved for the judges. So I think we can encourage them to do their task, but with a close look at the scientific aspects of disputes. And I'm happy to hear that and I do believe that time works for us, because as we educate our law students about quantitative methods, and I do see this trend that luckily legal research is now orientating towards quantitative methods and empirical studies. I think this divide between scientists who understand math and lawyers who do not understand math will disappear, because the world is just not so compartmentalized anymore. So. And I think international adjudication would benefit from tearing down these walls that are really destructive at the end of the day.
Thank you. We've got a question from Agnes Chon. His question is, in adjudicating on environmental risk, do you have a view on whether there can be or ought to be a criterion for determining the risk of damage?
Yeah, risk assessment, scientific risk assessment processes are very tricky in international adjudication. So it's again a very apt question. So we see that the significance of risk is is again presupposes a balancing exercise, what can be deemed significant and what is not significant. And in this respect, I've examined many decisions of the International Court of Justice, which had to evaluate the lawfulness of environmental impact assessments. And in this respect, I've seen this trend that the International Court of Justice and other international courts as well tend to decouple the notion of risk from the science of risk assessment. And this is a very dangerous path. So in this respect, I do believe that, yeah, there are scientific benchmarks for risk assessments, but again, these risk assessments cannot provide a clear-cut answer, because risk assessment is in fact in itself, it has a scientific core and it has some normative cloak. So what a certain community deems as acceptable risk, it does not depend on science. It depends on the normative choices of that community. So my answer would be twofold. So yes, it has and it should have a scientific core, and there are scientific benchmarks to assess risks. But at the end of the day, we have to acknowledge that that scientific risk assessments are scientifically informed value judgments, and so their review process, I believe, ought not to be preserved for only scientific considerations, because normative choices about the preference of that community, about normative values such as the precautionary principle and stuff like that, should have a say in scrutinizing the risk assessments of states.
Okay, thank you. And we are approaching the end time, and I wonder if you have any final words for our audience.
I'd like to thank you again for having me here today. It's a wonderful opportunity that despite all this pandemic, we can connect with each other, and I'm very happy that you've interested in my topic, and I do encourage everyone to engage in interdisciplinary research within law and within every other field as well, because it's just a very interesting exercise to combine insights from different fields. And thank you again for giving me time to present my research.
Thank you. And I'd like to invite all of us to join me in thanking Dr. Katalin Sulyok for being with us today and for this wonderful talk that she has given. And I'd also like to mention that Katalin's book is now available in the HKU library in electronic version. So if you want to check it out, it's very convenient. Okay, thank you.
Thank you so much.